So, good morning. Today I will be discussing based on my understanding of what I have learned on the previous lesson of Attorney Ferdinand Sales. It is stated on the Article 1318, there is no contract unless the following requisites concur. Number 1, consent of the contracting parties. Number 2, object certain, which is the subject matter of the contract. And number 3, cause of the obligation, which is established. Good day, so I am Rosemary Dirizabal from BSBA MM2B. Today I will be discussing the following requisites of the contract. Although a contract is just a piece of paper that you sign to seal the deal, you can still end up in a court due to misinterpretation. There are basic elements in contract which need to be present before any deals can be made. Ano nga ba ang contract? A contract refers to an agreement of two or more contracting parties on a particular venture whereby one person binds himself with respect to others to render services or give something. The contract must not be obtained through undue influence, coercion, misrepresentation, and fraud. As a general rule, the party who has suffered due to the breach of contract can claim money damages from the other. The breaching party will also be ordered by the court to perform obligations that are stipulated in the contract. The basic elements of the contract is the consent. Let's now dissect the following requisites of a contract. Article 1318, there is no contract unless the following requisites concur. Number 1, consent of the contracting parties. Number 2, object certain, which is the subject matter of the contract. Number 3, cause of the obligation, which is established. Article 1319, consent is made manifested by the meeting of the offer and the acceptance upon the things and the costs which are constitute the contract. The offer must be certain and acceptance absolute. A qualified acceptance constitutes a counter-offer. Acceptance made by letter or telegram does not bind the offer except from the time it came to his knowledge. The contract in such a case is presumed to have been entered into the place where the offer was made. Example. So Carlo offered to sell his car to Stella for 1 million pesos. Stella still didn't give her consent to buy the car of Carlo. And then Carlo decided to withdraw his offer to Stella. He will not for sale his car anymore. So question, is Carlo allowed to do so? That he withdraw his offer to Stella? Of course. Why? Because there is no perfection of contract yet. There is still no consent coming from Stella and there is no meeting of minds of both parties. So Carlo is still allowed to go back out to his offer. Let's talk about now the requisites of consent. Number 1, there must be two or more parties, of course, that is involved. Number 2, the part must be capable or capacitated. Of course, in order for you to give a valid consent, you must be capable or capacitated. For example, person with mental illness or disability, how can he provide his consent? Even though he gave his consent, still invalid because of his mental capacitated. Number 3, there must be no violation of consent. There is no fraud, intimidation, or any other action that can affect the consent. It must be voluntarily or intelligently given. yung hindi ka pinilit para ibigay yung consent mo. Hindi ka tinakot. And number 4, it must be exactly declared on what is on the contract was really intended. Number 5, intent must be properly declared. Whatever the legal formality required, it must be complied with. On the next paragraph of Article 1319, offer must be certain and the acceptance absolute. When we say certain, the offer must be definite and seriously intended. Acceptance, absolute meaning not qualified, it must be unqualified. Acceptance must be absolute, not a counter-offer. Like the example a while ago that Carlo offered his car to Stella for 1 million pesos, and Stella must said yes to accept the offer, or yes, I agree, because if Stella insists to offer 800,000 instead of 1 million, it is a form of a counter offer. The time that he insists to offer 800,000 from original price, there is no meeting of minds of both parties. It has a rejection of the original one. On the third paragraph, acceptance made by letter or telegram does not bind the offerer except from the time it came to his knowledge. Example, on May 6, Carlo offered his car to Stella for 1 million pesos by letter. So, Stella received the letter and consented to buy the car of Carlo. Well, the letter is on the process upon mailing. Carlo died. So, question, is the contract perfected? No, of course, because that either the parties before the acceptance actually renders the acceptance ineffective, because it is said that it will become binding once the acceptance which made by letter was came to his knowledge. So, if Carlo died upon the process of mailing, then the contract didn't came from his knowledge anymore. In general, when a consent is given, the contract is considered perfected. It can be deemed an oral contract that binds both contracting parties. One person must have definite offer and the other must have an absolute acceptance of the offer. Consent is the meeting of minds of both parties. The consent was not secured by force, by violence, by intimidation, or by mistake. Gaya nga ng sinabi ko, kailangan hindi ka tinakot or binigla para lang maibigay yung consent. The second requisite is the object certain, which is the subject matter of the contract. The subject matter refers to the object of the contract. If a thing is deemed outside the commerce of man, it will not be accepted as the object of the contract. For example, kanina, si Carlo ay nag-offer ng car kay Stella. Ang car is the object of the contract. So, the object of a contract is the thing to be delivered or the service to be rendered. For example, on the contract of sale, on the part of the seller to deliver the object, or in the part of the buyer to pay the purchase price. Other example of contract is contract of lease. There must be meeting of minds of lessor and lessee. Contract of agency, contract of loan. It binds both parties once it is perfected or performed. There is the happening of meeting of minds of both parties. Causes of the obligation which establish. It could be the purchase price, transfer of ownership. It could be the enjoyment of the things, transfer of the possession, or the causes of the obligation. Purchase price obligation means the obligation of the guarantor under the guarantee to make payment to the seller of the purchase price. While transfer of ownership, in the contract of sale on the part of the seller to deliver the object or the things on the part of the buyer to pay the purchase price. Contracts are made to transfer the rights of property, render services, and others. However, the object of the contract must not be contrary to law, good customs, morals, and public order. In a specific sense, causes of the obligation which is established. It could be the purchase price, transfer of ownership, it could be the enjoyment of the things, transfer of the possession, or the causes of the obligation. Purchase price obligation means the obligation of the guarantor under the guarantee to make payment to the seller of the purchase price, while the transfer of ownership in the contract of sale on the part of the seller to deliver the object or the things on the part of the buyer to pay the purchase price, while on the contract are made to transfer the rights of a property, render services, and other. However, the object of the contract must not be contrary to law, good customs, morals, and public orders. In its specific sense, law has been defined as a rule of conduct, just, obligatory, promulgated by a legitimate authority, and of the common observance and benefits. A contract intended to circumvent and violate the law is void of nation. Thus, an agreement to convey homestead only after the lapse of 5 years, period during which under the Public Land Act, the owner was prohibited from transferring his rights cannot be enforced for it's clearly illegal. Morals deals with norms of good and right conduct evolves in the community. These norms may differ at different times and places and with each group of people. Example, an agreement to pay usurious interest is contrary to the usury law. Custom consists of habits and practices which through long usage has been followed and enforced by society or some part of it as binding rules of conduct. Example, husband and wife entered into an agreement to separate mutually and voluntarily. A notary public ratified a document entitled Legal Separation, executed by the husband and wife, wherein they agreed that they separate mutually and voluntarily, that they renounce their rights and obligations, and they authorize each other to remarry, renouncing an action to which they may be entitled, and each promising not to be witness against the other. Public order refers principally to public safety, although it has been considered to mean also the public well. Example, contract legalize the commission of adultery or concubinage. Public policy is the broader than public order, as the former may refer not only to the public safety but also the consideration which are moved by the common good. That's all the three requisites of contracts. Take note that the absence of one will render the contract defective. That's all. Thank you for watching.